Hello.
Hello, is that Mr. Hussain?
It is, yes.
Hello, it's Sian calling from the legal ombudsman.
Oh, hi, Sian.
Hello, I said I'd give you a call around 2. Is it still a good time to speak?
Yes, it is, yes. Obviously, I was looking forward to
Oh,
your call. And I think it was just, I wanted to discuss with you your comments that you've requested. I mean, the reality is that you had sent these over, I think on the 22nd. Is it the 22nd of May?
I'll have to double check on that. But just before we go any further into some detail, can I just go through some security questions with you?
Yeah, sure.
Thank you very much. So just confirm these solicitors that the complaints against.
Burke Niazi Solicitors.
Thank you. Your email address.
It's fatabegum@gmail.com.
Thank you. And your full name.
Mr. Sajjad Hussain.
Brilliant. Thank you very much, Mr. Hussain, for that. And just as a reminder, as you know, calls are recorded, but they are merely for feedback and quality purposes, okay? So let me just double check. I'm sure it was around that time. It would have been 2 weeks prior. So just double check the exact date of that. Let's have a look. Apologies, sorry, my system's running a little bit slower today.
Yeah, sure.
So yes, it was the 22nd of May that request. Well, the notice was sent, yes, and we had a conversation prior to that, didn't we?
What date does that conversation take place?
Oh, I'll have a look. Just bear with me. It was, like I said, we do have all our interactions recorded. So let me just search for our telephone call. So I believe that was on the 15th.
Yes, the 5th. Let me just see. That was on the 15th. Did he say yes?
Yes, correct. Yes.
Okay, and what was the time before that?
Just bear with me. Let's have a look. So that was when we discussed it. I'll just search phone call records. So at the moment, I'm searching all our correspondence, which is obviously bringing up quite a bit. And the previous time we spoke was on the 4th of May. Before that.
Okay, so you got the 4th of May and the 15th of May?
Yes, correct.
Okay, well,
hello?
I'm just 1 second, please. Because I got the 11th of May when we last spoke. Maybe I made a mistake.
Let me just double check. It might be. Let me just double check my call recording list. The 11th of May. Apologies, sorry, it is the 11th of May. I'm looking at the wrong telephone call, but yeah, Mr. Hussain. So yeah, we had a 2-part call, didn't we? So I think we just got broken up in between due to some issues I had on my side. So yeah, that was right. I think our first half of the call was around 40 minutes, and the second half of our call was about an hour.
Yes, and so that was the incident where you had informed me of your decision of looking to discontinue. Seeking informing the ombudsman that you're looking to discontinue, the investigation. And I had asked you to give me an explanation of this over the telephone briefly, and you had proceeded to do so. And then subsequently told me that you'd be writing out to me, with the fuller details. So following our conversation on the 11th of May, you then proceeded to write out to us on the 22nd of May, with those details, and asked for comments by the 5th of June. And obviously, I've now had an opportunity to read your, because obviously on the telephone conversation, it was the first time you had made me aware of the situation, isn't it? On the 11th of May.
Correct.
I was quite surprised and startled to learn that you had made that decision at that stage of the of the dealings with this case. But I'm just looking at my records, and the telephone conversation we had prior to the 4th of May was on the 14th of April. Is that correct? When it was you were explaining to me that you've now received a response from the solicitors regarding all the outstanding premature complaints.
Just going through my call record. So Just to clarify, obviously today we're just here to discuss
Yes, yes,
your
yes,
comments regarding
yes,
the 5.7 challenge.
yes,
What I will do as well, obviously, I'll pass this phone recording on to the Ombudsman when I make the request today, and
yeah,
obviously
sure,
they'll have a recording of all our
yes.
communications and calls. So, like I said, I think the previous call I have recorded for us was we spoke on the 11th of May, as you said, and then the 4th of May.
Yes, and the one prior to that was on the 14th of April.
Have a look. Yes, the 14th of April, correct.
Okay, the reason I mentioned those dates is because obviously on the 14th of April you were not in a position to make any decisions because at that stage you had just received an answer from the solicitors. And is it not correct that we established then that all the 20 complaints all the 20 complaints brought to yourself, they have unilaterally just denied all of them, haven't they? They've not agreed to anything. They've just simply said no.
Yes, correct. That was my understanding of what they've advised.
Yeah, so they're just
they
basically
stand by that they gave a reasonable service.
yeah, so they're just basically disagreeing with all the 20 complaints. I then asked for, well, I would like to know what exactly they've said, and you said you look into this and get back to me, because I just wanted to know something from them. So they're not providing me with anything, or what they've told you, and you said you look into this. And I've still not received anything from yourself regarding what they have told you, because ultimately I'm going on what you're saying that they have said.
Yes, correct. I think I did let you know in an email. I'll have to go back on the records to get the exact date of those
Okay,
emails.
no problem. No.
But I think I did advise that what we do as part of our process is when it comes to premature complaints, so to speak, which is what we've dealt with, I think, around date, didn't we? We will get the response from the service provider and we'll share that with you via email or telephone call, whatever complainants prefer. And obviously we prefer to speak over the phone. So I've shared that with you verbally. Now, obviously, I know you requested their responses in writing, and just part of our process is we can share those responses in writing if the service provider consents to us to share those written responses. So we do that. In this case, the firm didn't really come back to me in terms of giving consent to share those written responses. So I was unable to do so. And I think we did discuss it because I think obviously you said that you wanted to put in an information request.
Yes.
I said that if you did want them written responses, it would be a case that you put a subject access request in.
Yes, and I proceeded.
And obviously, following the last time we spoke, I did confirm that. So I don't know if they have been in touch with you yet.
Yes.
But they did come back to say that they received my request on your behalf, and I think I confirmed with you, didn't I?
Yes.
Following our call that request had been made.
Okay, all right. Yes, I mean that is the case. So basically, all I'm just trying to establish is that on the 14th of April, the final response from the solicitors had been reached by yourself saying that we deny everything, and then subsequently I had requested what exactly have they told you, and you've gone back to them asking for permission. They've not really responded to that inquiries, but you've advised me an alternative route, which is obviously to make a subject access request. And then now moving forward, we had a very comprehensive discussion on the 4th of May, where you would then proceeded to make an evidence request. Can I ask, when was that evidence request made? Was it made on the 4th or after the 4th?
Let me just have a look. I won't be a second. Let me see the date of the document that I sent across to you. That the evidence request was made on the 28th of April.
All right, so on the 28th of April, you made an evidence request, and I've promptly responded to that evidence request by having a telephone conversation with you on the 4th of May, haven't I?
Yes, correct. We had a telephone conversation,
but the other party, you made an evidence request on the 28th of April, on the 28th of April, yes, and the other party had requested a time extension for the evidence request. Is that correct?
Yes, correct. And I'm managing that with them.
Yes, and then what date did they requested an evidence request for the 25th of May? Is that correct?
Yeah, if that's what the email says, yeah.
Yeah, but then they've come back and said we want more time yet.
Yes, that's correct. I'm in the process of managing that with them.
Yeah, okay, all right. And how much more time have they requested, or how much more time have you provided? Because remember, you made the evidence request on the 28th of April, I just wanted.
The thing is to say, I do have another call at 2:30 today, and I appreciate, we're establishing facts of what's
Yes.
happened, but obviously we can go back on that. But my evidence request with the firm, I am managing, but that right now, my priority is to try and get this moved forward with the 5 points.
I understand.
So what we need today, and obviously rather than discuss it, because we have previously discussed my request, what I'll do is I just need to take your comments verbally.
Yes, that's fine. That's
so
fine.
I can now pass that on
I understand.
to the Ombudsman.
I understand, and obviously, if you, I was not aware that you had limited time, but obviously, I need to be, given that opportunity. It just seems, obviously, on the one hand, you're explaining to me that you're impartial and you don't want to act favorably. However, it just seems to me that all of a sudden, you're putting me on the spot, asking for these comments by a specific deadline date, and I would like to have an opportunity to fully express myself and give you a fuller context, considering that when we did last speak on the telephone, I did explain to you that you explained to me that you'll be asking for my comments, and I did explain at our last conversation that yes, I will be providing my comments, but I will be providing them orally. And our understanding following that conversation was that I will be providing those comments to your manager, hence why I asked to speak to your manager. And then subsequently, your manager has got in touch with me, looking to arrange a telephone call for tomorrow. Unfortunately, that was not available, and then subsequently I'm still waiting for a response to that. Subsequently, you've told me that your manager will not be taking on the comments, and it would be yourself that be taking on the comments and ask for those comments and evidence. And then and hence why we're having the telephone conversation today to give you my comments regarding your decision. But I mean, if this time is I don't understand why that you need to press us upon time restrictions right now, considering you've been more than generous with the party to give them an extension of time for evidence. Can you explain to me what the critical point is that you need to send this to the Ombudsman without delays?
So, sorry, Mr. Sian, I'm not quite good. The only reason I mentioned today is that obviously, like I said, I intend to submit it to the Ombudsman.
Yes.
But in terms of all I need now is your comments.
Yes, I understand.
I appreciate, obviously, we want to discuss it, and I can always try and push my call back a little bit. That's an internal call. That's absolutely fine. I want to make sure we capture all your comments.
Yes, I understand.
Because ultimately, the Ombudsman, needs all your comments as well. So I fully appreciate that.
Of course.
The time management issue I've got at the moment with the service provider and the evidence, the extension was regarding the evidence. This is just the comment for the dismissal.
I understand.
So I thought, we should have enough time to discuss, for me to take the comments. So, for example, what I'll do is, I'll send them a copy of this call, of course.
Yes,
so
of course you will.
Hear the call and get your comments that way. But I'm also making notes as well for anything. So, for example, you've said, you do feel that it's unfair that I've given the service provider, an extension of time in evidence, but again, you feel that I'm not being impartial in that. So I will take that. I'll note that down for the Ombudsman to obviously review, and obviously they'll have a copy of this call as well. Yeah,
sure. And so what I'm trying to establish is that you've been you've acted in a discriminatory manner against myself, which is highly prejudicial. Hence why I'm saying that, look, you've given them an extra account, you've made an evidence request from them at the same time that you've made an evidence request from me on the 28th of April. I then proceeded to contact you and attempted in my own way to provide you with the evidence. They've asked for an extension until the 25th of May. You've provided that extension to them. They've subsequently come back to you and asked for a further extension of time. And, you've also agreed to that. And conversely, you're asking for my comments because I've already supplied my evidence request or attempted to meet your evidence request. You've asked for my comments and I said, yes, all right, I would like to present them orally. And there's been some confusion about either giving you the oral request or giving somebody else the oral request, namely your manager. And, we're at this stage now, and all I'm trying to establish is that, yes, I would like to give you my full comments, so which the Ombudsman should be privy to, which you're quite clearly agreeing with me on. But then you're also putting like a time constraint or a limitation on. And if that is the case, then if we don't have enough time today, or you've got another pressing call, then we'll have to rearrange for another time. But I'm just trying to understand from yourselves what now is the urgency of escalating escalating this matter to the Ombudsman without giving me the full opportunity to fully comment. I mean, like for example, we'll try to get through the my comments if we can today. But if it is such the case that you need to go for another call, then we can push it back. So I'm just trying to understand where's the urgency now to get this to the Ombudsman.
Okay, yeah. So, like I said, in terms of the urgency, there's no urgency as such, Mr. Hussain. It's just a case that we follow procedure, and I want to try and get it moved forward as quick as possible.
Yes.
In terms of comments, like I said, I believe that we would have had adequate time for me to take your comments, because today all I'm really doing is just noting your comments down and obviously recording them on the call for the Ombudsman to listen to.
Yes.
So it was my view that we would have enough time today for me to take your comments. Absolutely, if we need longer time, I'm happy to try and push I'm happy to push my call back. It is an internal call.
Okay, all right.
That's not an issue. My priority is to obviously give you some time today to give me your comments, because I do think it's important to capture everything so that the Ombudsman has views.
Yes, and I'm fully in agreement with you.
This is the dismissal is my opinion as an investigator. And this is why we have these procedures in place. So, this is why we have a procedure in place for the Ombudsman to review everything independently. So, I'll full disclosure, and all your comments I'll share with the Ombudsman.
Sure.
In writing, I'm making notes on phone. So,
it's just that.
So you go ahead, and I'll make a note as we go along.
So can you understand that? First of all, I just need to get clarity of why I feel right now that I'm being basically put on time on time constraints, which is not really necessary, because obviously, like I said, if there was an urgency to get this to the Ombudsman without delay, then I can understand the time constraints. But I think it's highly. I feel that you're putting me on the spot effectively under a time constraint, or like limiting it 30 minutes. So I would like to have the opportunity to fully express myself. And often, Sian, in our conversations, they often do take a long time, because I do like to fully express myself to a point where I'm satisfied, and that often takes more time than necessary. So hence, I'm grateful that you're giving me the full opportunity to give you all my feedback. And as you've explained, that this is your decision, and I believe that your decision is discriminatory and prejudicial, and I would like to obviously give that feedback rather than saying the general term. I mean, that's my position. Your decision is discriminatory and prejudicial, but that's just like a sweeping comment, isn't it? I would like to obviously proceed to support that with evidence or with facts, rather than just making a sweeping comment. No doubt you're going to disagree with me and say, no, I've acted impartially, I've not acted discriminatory against you. Then obviously, hence why I'm actually trying to establish facts with you. Hence why when we started this conversation, I just asked you to, let's go over what the telephone calls that we've had, what kind of facts are we dealing with here. So hence why I'm asking. So I'm basically now looking to make an argument that you've acted in a discriminatory manner throughout the handling of the case, which ideally I would have escalated to your manager, but those will be specific complaints that I will raise with your manager. However, in the context of providing comments to your decision, because obviously this is yours, claiming that this is your decision, I just want to establish that your decision is prejudicial based on these facts, which obviously are facts you can't deny, can you? Like, for example, you're not going to argue with me and say that, no, I did not make the evidence request on the 28th of April. You can't disagree with, you can't argue with me on that. That's a fact, because you have it written down. I have it. So it's all to do with your motivations now. So obviously, as you can appreciate, if you were to say to me that, well, I'm going to give the other party an extension of time to submit the evidence request, but I'm not going to give you that extension of time, would you agree that's discriminatory and unfair?
I'm happy to give you an extension if you need, in terms of providing evidence. It's just that the evidence you provided, it's not suitable. So it's slightly different reasons. But I will note that down.
Yes, of course. What I'm just trying to establish is that you should treat both of us fairly, and I don't think that's happened so far. So, and I'd just like to give you examples which are, factual, which are not open to contestant, because obviously they're factual. So you've provided them with an extension. Initially, they've asked for an extension and provide them to the end of 25th of May. They've asked for a further extension. You've agreed to that. So I'm just trying to say, have you what date did you agree to? Because that's all. I think it's only fair for me to understand that, yes, if you feel it's justified to give them an extension, it can't be like, I'm going to give you a limited extension. So initially you had asked for the on the 28th of April, you had provided a deadline date, I believe the 9th of May. I'm not sure what date that was, but you had given them a specific deadline date. You then extended that to the 25th. But now, can you understand, I'm just trying to establish that if simply given them an open-ended extension of time, that's discriminatory. So can you tell me can you tell me, or evidence on will be evidential that you've given them a specific deadline date, or you've just simply told them, all right, you can get back to me whenever you want?
Well, I'm managing that with the firm directly, and I will continue to do that in
Sure.
the background of this.
Sure.
So I'll note your comments down that you feel that way, and obviously that is an example of why you feel that I favoured the firm in the investigation.
Okay.
And it's also something you can raise with my team leader as
Yes.
well. I think you said you've got a call planned this week with him, haven't you? So,
well, no.
Listen, all
Yes.
I'll say at this time, that Mr. Hussain, is that I am managing that with the firm
Yes.
directly. It is, my investigation to manage.
Yes.
I'm managing that with the firm directly.
Yes.
Again, that's not my priority. It's
Yes,
my priority
sure.
to get this moved along, because
Sure.
I can't review any evidence,
Yes.
even if they were submitted,
Sure.
until this
I know.
this dismissal request has been resolved.
I
Okay.
I understand.
So that's where I'm at the
Yes.
moment. But I'll absolutely take your comments on
Sure.
board and note them for the Ombudsman.
So exactly, that's what I'm trying to say. I'm not asking you to review the evidence. I'm simply stating that you're acting in a prejudicial manner, where in the past you've made both parties aware that there's an evidence request, and then provided a deadline date. You provided, I believe, I'm not sure what date that was. I think the 9th of May and stuff. You've then subsequently informed me that I have agreed to the extension. So you've already disclosed that to me. You also then disclosed to me the date of that extension of time, because obviously when we last discussed the conversation, I was asking, will that fit in with the subject access request? Because obviously I'm quite keen to understand what the evidence is. And then subsequently you've said that I've agreed to a further extension of time, but at this moment in time you're not willing to tell me what that date extension is.
And I've noted that comment, and again, I'll you can raise that with my team
Yeah,
leader
sure,
as well.
sure. So, but that's what I'm trying to say, is that you're not willing to provide me with the extension of date of time, which leads me to believe that effectively you have advantaged them by, making it open-ended. You have informed the other party of your decision to discontinue this investigation, haven't you? You've informed them, haven't you?
Sorry, just repeat that again for me.
Sorry, I'm just trying to say that, you've informed me of your decision to discontinue this investigation. You've also informed the other party of your decision, which you had informed me in writing on the 22nd of May. You've also, the other party also know this. They've asked for an extension of time. You've agreed to that extension of time. But effectively, it seems that you've by not giving them a date or further deadline date, it seems the fact that you're already presumptive enough to believe that the Ombudsman is going to discontinue this investigation. So that's why I feel that you're acting prematurely, because evidently, if you had provided them with a further extension date, you would say, Mr. Hussain, well, yes, I've agreed to a further 2 weeks extension for them to get the evidence to you. However, irrespective of if they do provide me with the evidence, I will not be reviewing it, because obviously my priorities are to deal with a dismissal of this investigation. So because you've not provided an extension of date, you have acted prematurely with the outcome of the decision, because right now you're explaining to me that the Ombudsman is not aware of this case, and because you've not submitted your case dismissal, but you're also acting presumptuously. Effectively, you're saying that to the solicitors that, I'm not going to continue this investigation. I've already given you a deadline date of the 25th of May. They've come back saying we want an extension. You said, yeah, just get an extension, because ideally I believe that this investigation is not going to go anywhere, and therefore I believe that you've acted presumptuously, because you've not providing me with the date of that extension of time, and you're not willing to do so, and I'm not going to press you upon it any further. I'm saying that establishes that you've acted in that particular case in a discriminatory manner, because in the past you've provided me with a cut-off date, and now you're not providing me with a cut-off date for them to submit the evidence request. So I think that's prejudicial. Those are the only comments that I'm trying to make in this context.
Yeah, I fully understand that. I've
Sure.
made a note of
Okay.
them as well.
So moving on from this, it is a factual that I have attempted to provide you with evidence. I mean, I understand there are some questions regarding the format or exactly what you've asked for, but it is correct that I have attempted to provide you, comply with your evidence request, isn't it?
Well, you provided me, I
Yes.
think it was a link to the copy of the YouTube channel. I
Yes.
said it was not suitable. Yeah.
Yes, but I've attempted to comply. They equally have not. They've not complied. So, as it presently stands, they've not. They've not. They may have. They've not complied with the evidence request number one, and they've not provided any evidence for yourself, and also they have provided you with their comments, which as yet I've not received. So I've got nothing from them, and the only thing that they've provided, informed you of, is that we do not accept the 20 complaints, and also that and these are our comments. But those comments I've not. Basically, what I'm trying to say, I've not got anything from the other party that I've given to you. And they've not even provided any evidence, complied with the evidence request. That's factual, isn't it? Yes.
Yes, correct.
Yes.
I've noticed
Okay.
that. Yeah.
And also, I find it highly prejudicial that from, I mean, you asked me for evidence requests, and I've made it quite clear that I should not be relying on evidence, because obviously one of the problems we've had, and one of the first things that you've informed me of at the very beginning, is that it is not your policy to request a cold case file. If you recall that you said I will not be doing that, and obviously I feel that under these circumstances that decision of yours early on has effectively sabotaged any independent, comprehensive investigation into this matter. Now, I understand the logic behind not requesting the whole case file. Now, as you can appreciate, if a case file is 2 years old, and a lot of things are happening on the case, and a complainant such as myself would be complaining about a particular issue throughout that 2 years on a specific issue, then it is reasonable on your part as the ombudsman to say, well, we don't need the whole case file, because most of that is redundant. All we're looking to do is focus in on the specifics of the complaint, and therefore our evidence request will be limited. However, I believe the approach that you've taken is highly prejudicial against any kind of fair assessment, because my complaints are from the start of the case file until its conclusion, and it was over a year period, and obviously the 20 complaints encompass the whole case file. So for you to state that I'm not going to be making a request because of the procedures that we have in place, I believe that you've acted not taken the holistic approach and said, well, actually, my initial complaint is from the very first day that the case was started, and then subsequently it's followed through, and all the way until the matter was concluded with. So I think that position is highly prejudicial. Now, I'm not sure if you're aware of this, or in the background there's been other issues in relation to a different matter. Basically, I'm not sure if you're familiar with this, but it's in the news that there is being a public inquest into Boris Johnson's handling of the COVID case. An independent inquest has made a request for all the information from the Cabinet Office. The Cabinet Office have objected to this, saying, well, we don't want to provide you with all the information because it's not all relevant, and so that's now taking a legal case. They're taking a legal case regarding this. But the purpose I highlight that is because I'm just trying to understand what the ombudsman's role is. If it's equivalent to an inquest or an inquiry, it is not unreasonable to request full disclosure of evidence to be investigated. So in this particular example that I'm giving you, an inquest is taking place into the handling of the COVID-19 crisis by Boris Johnson and the cabinet. The inquiry, the lead of the inquiry has asked for all documentations like WhatsApp and all diary information to be given to the inquest. And the argument that's been put forward by the Cabinet Office is that, well, you don't need all of it, so we're not going to give you all of it. And that has resulted in a dispute being escalated to the court. So that's something that's ongoing presently outside of, what we're talking about here. But it just highlights to me that when something is being investigated, like yourself are investigating my complaints, that it would only be relevant to a request for all of the information regarding this case file, considering my complaints are substantial and throughout the course of the complaint. Because you haven't done that places me at a disadvantage and to an advantage of the solicitors. Like I said, for example, if it was an isolated incident, then by all means take the pragmatic approach to only get that information relevant. You don't need all the information, all the other case file. But under these circumstances, you've not executed your judgment properly by saying that no, I won't be making an evidence request for the whole case file, when I've said that is the foundational basis of what has failed, has been a failure of service. Because I then explained to you that I have made a request for this case file and it's not being complied with, and I've had to escalate this matter to the Information Commissioner's Office, who have advised me that if I want to pursue this matter, it should be a legal matter that I should pursue against them. They're acting as an advisory body, not as a regulatory body under my case situation. So once again, I'm left in this situation where the problem is the case file, which you as the Ombudsman do have the power to request, and would have been a right judgment call, but you've not done that. And then subsequently you've made an evidence request from both parties, and I feel that it's basically you've already set this up to fail, because I've explained to you that the evidence is all emails based. They already have this email information. Should they provide that evidence, then you have that information, and I just remind myself that the evidence that they are basically obliged and obligated under their business operations to collect evidence of what work they're doing, because they're a solicitor's firm. I'm not obliged to collect any evidence or present any such documentary evidence which is already accessible. And I think I've mentioned this before, but I think that because you have failed to make an evidence request for the whole case file, that's slightly been prejudicial. And then when subsequently I've proceeded to explain to you that it's not necessary for me to provide that information, because that will be a duplication of the information that the other party should be holding and providing with, and it would be disingenuous of me to provide information that would already be available. However, I did explain to you that there is information that they would not be holding, namely my call recordings with them, and that obviously would be relevant to yourself, and I then proceeded to provide you with this, although it may not be in the format that you've requested. But the bottom line is that when you had made the singular decision to not request the whole case file, I believe that you've acted in a prejudicial manner, because you've not taken into the context that my complaints were all encompassing from start to finish, and that was prejudicial on your part. Is that understood?
Yeah, I've noted that down.
Okay, all right. So now I wanted to speak to the specifics of the comments in relation to, your grounds for dismissing the investigation. One of the things that you have stated is that I think I personally believe that once what you've attempted to do is basically grab at straws effectively to force this into your framework to have it dismissed. I remind myself I had a peculiar conversation with you on I believe the 4th of May, where you were asking me, I believe, not inappropriate questions, but questions that were like slightly at odds. Effectively, you were asking me, well, why am I pursuing this? What is my ulterior agenda, and so on and so forth, which I thought on the 4th of May was highly dubious to be asking me those questions. However, you asked me questions like, what are you ultimately hoping? How can this be satisfied, and so on and so forth. At that stage, which was, after a point where you had accepted my complaints and the matter was at the stage of evidence request, you then started to ask me questions, which obviously the ombudsman can review, which I at the time found slightly dubious and unusual, because we had already gone through this process quite early on. But you, on the fourth, you were effectively I feel that you were trying to fish for information in order to undermine the investigation. So there was an element of deception on your part, where you were effectively trying to coach me into giving responses that would have assisted you in finding grounds to dismiss the investigation. So that's what I believe that you were attempting to do, and that obviously can be reviewed by an external party, that if whether that holds ground or not. But at the time, I just thought it was slightly odd of you to ask me these questions, which we had already discussed at length previously, because you had already told me the role and remit and the limitations of what the ombudsman can and cannot do. And in that conversation on the 4th of May, I did explain to you that obviously there can effectively be no resolution through what is the resolution when I'm making the allegation that my mother's been murdered. So in response to this, you had stated, look, I'm really sorry about how you feel about that. So effectively you were on the 4th of May, which is a call that does need to be reviewed by the ombudsman, which I've reviewed, where you were effectively coaching me to give answers to justify you discontinuing this investigation at such an early stage. And I at that stage I said, well, what can be the resolution when I'm holding out to the position that the solicitors have effectively worked with the authorities to end my mother's life? And you said, well, obviously there's nothing that we can, that's not something that we can do. And I was quite clear to yourself that yes, I have my intentions, and you were asking me the wider context, and I was openly being transparent with you. Yes, of course, I look to pursue litigation action against the firm, and there are other ongoing issues that are circumventing this. But you did advise me that, and in that conversation, you did advise me that, Mr. Hussain, there's nothing preventing you from pursuing those actions concurrently whilst we're investigating this. And I agreed with you. Yes, there's nothing. Not in your investigation. However, there are other aspects that I need to take into consideration, so it's now not the most appropriate time. And you also advised me that I can go to the solicitors ombudsman, the solicitors regulatory authority. But it is just clear from these conversations that we've had previously, and the reason I was dubious is that we've already had these conversations previously at the start of the investigation process, where you had fully advised me, and so for you to advise me again on the 4th of May was highly dubious and circumspect. But is it not agreed that if I was to take this matter to the solicitors regulatory body, that they will not be able to provide me with any financial compensation, will they? All they can do is take a regulatory action against the solicitor's firm, but they cannot financially compensate me, can they?
No, that is not their role.
That's correct. Yeah. So we had already discussed this at the early stages in January. What the limits are, what the scope is of your remit, and you already have made me aware of this. And then for it to be reiterated on that particular call on the 4th of May, that look, nothing's stopping you from going to the regulatory body, the solicitor's regulatory authority. And I said, yes, nothing is stopping me, and maybe that's an option I would explore. But at that stage, I was being open and transparent with yourself and giving you a fuller view of what my intentions are. And I just feel the fact that subsequently, in comment to your dismissal grounds, you've utilized comments and opinions that I've expressed to you in passing after I feel that you've coached me into giving you the justification to discontinue this investigation. And I feel for those are disingenuous, that's very disingenuous on your part, where you have preemptively looked to effectively sabotage this investigation from the offset by refusing to make a complete disclosure request for the whole case file. And then subsequently, after failing to do so, you're effectively coaching me to give you answers that would fit into the framework of getting the case dismissed, because what you are privy to is the schedule of scheme of the ombudsman to have the investigation dismissed. I am obviously not privy to that. I was not privy to that, especially on the 4th of May. Subsequently, you've provided me with, that schedule. So it just seems to me that at that stage, on the 4th of May, you were trying to find reasons to have the investigation, find grounds to justify the investigation not going ahead. And I feel that is highly prejudicial and discriminatory, because at this stage, in that conversation on the 4th of May, I had not provided you with my evidence disclosure, and neither had the other party. It is only after the call or during that call I had informed you of the link to the my call recordings, or attempted to provide you with evidence. So I feel that you were effectively coaching me to give you answers to fulfill your criteria to have the investigation stopped. But then subsequently following on, so that's what I would like to make clear, is that I believe that on the 4th of May you were coaching me to give you answers that would assist you or justify you to ending this investigation prematurely, because you had not you had not received my evidence at that stage. So that's what I'm alleging, that was highly discriminatory on your part and prejudicial. Then subsequently, during the call, I was insisting on giving you the YouTube video link, and your answer was that I am not sure if that, if I'm able to view that, and that's something I'll get further feedback on. I'll be looking to get that further feedback on both the, the particular IT department or appropriate department, and also from the ombudsman. So when I attempted to provide you with the requisite disclosure, of my attempts to fulfill that disclosure, you had first of all stated that you're not even sure that is in the correct format, and then subsequently you were going to seek advice from the ombudsman. But then you proceeded to say that, well, the way I would want it is in an MP3 format, or specific snippets of it in this regards, which would better serve your interest, because you didn't want to be going through the whole of the recordings, which is understandable. But I think, once again, the approach that you're taking was highly not the appropriate approach to be taken, because I cannot give you evidence of absence of absence of things. So for example, I've made, one of my complaints is that I've made numerous requests to speak to somebody, and they've not responded. So I cannot give you evidence of them not responding. All I can show you is that look, on these, it is evidence that I've called on these particular days, and I've proceeded to provide that to yourself, and you've asked for, like, to give you information. I cannot, can you understand? I can only give you positive evidence. I cannot give you absence of evidence. By its very nature, if somebody's not given me something, then I can't give that to you, because they're not giving it to me. It's an omission, not a commission, effectively. If something's been commissioned, it's evidential. If there's an omission, then there is, it's by its very definition not evidentiable. But then, so therefore, in order to meet that requirement, I've then provided you with everything, and it was not something that I would I disagree with you on. And then subsequently, one of your comments is that I've refused to engage with you in your you comply with your requests, and that is frankly not correct. All I've stated is that number one, with regards to any documented evidence that is available from the solicitors firm, so they have a copy of that, and you should request that from them, and not request a duplicate from myself. So that's not being obstructive. Secondly, that I've then proceeded to provide you with all my call recordings, which is once it's out there, it's not, I can't then retrospectively change things, and that's what ultimately the solicitors firm do. They retrospectively reconstitute evidences to meet the new criteria or change the goalpost. I can't do that. I've presented you with all the evidence, and obviously it's something that I would struggle with. I was just trying to explain that in order for me to go through everything and to kit out snippets of information and to give it to you in the format that you are particularly asking for, in an M33 format, as snippets in an argument that I feel is slightly, I was explaining that this is a very resource intensive thing for me to do, and it would be, disingenuous of you to burden me with that or not provide me with the framework. And I did explain to you that it's not, there is nothing prejudices me, nothing should prejudice me for not providing you with anything. And you have agreed with me that I don't have to provide you with anything, but then you will only be going on the information provided by the other party. So I should not be later on in your comments, this is one of the grounds that you're using, is that, oh, because I didn't choose to, follow your steps. It was something that was unconventional or unusual, because even you yourself have agreed that that is not normally how you would expect the evidence, and it's something that I'm sure we could have worked through. But for you to, use that preemptively as a grounds to dismiss, that once again shows a non-compliance on your part, or not a willingness on your part to liaise with me and to say, well, Mr. Hussain, I would really like it in this manner if you could assist me. Obviously on this particular case, if you can find for me. That was something that I could work. I was more than happy to work with you on, because the evidence of the call recordings was there in front of you. There was nothing like circumspect. If you needed further, if you required my further assistance to deal with those, I would have been happy to point those out to you. But it just seems to me that the approach that you would take, effectively, you were taking the approach to sabotage the investigation as effectively being an independent party. It was your intention to sabotage this from day one. That's what my contention is, and this is just a further illustration of this. And so that's the comment in relation to where you've made grounds to dismiss this case, is that my obstructiveness in engaging with you, and I feel that that is basically twisted, turned around, and factually inaccurate. I'm bringing the complaint to yourself. I am looking to engage with you. I'm obviously looking to provide you with evidence. I'm not looking to be obstructive. And obviously, this is the first time I'm coming to the Ombudsman, so I'm not fully familiar with your policies and procedures. And obviously, objectively speaking, I'll express my opinion and say, look, this seems highly prejudicial to me, which or disadvantages me, which I've articulated to you. But there, at no stage had I look to be obstructive. But can you see the converse? This is why me and the solicitors firm are not in the same boat, because your policy is that if the parties being obstructive are not complying, then that gives grounds for us to end the investigation. So it is in my interest for the investigation to be concluded. It's obviously not in the interest of the solicitors firm to be solicitors firm to have the investigation concluded, because there's only one action that can result, which is they're going to be found either vindicated or found guilty, or not guilty but found evidence against them. So if they don't comply with your policies, that should not be justification to end the investigation, because they're not interested to do so. But can you understand how that very simple statement of whether people are being obstructive in complying with requests is grounds for ending an investigation? It's not the same for me as it is for the solicitors. If it is in the solicitor's best interest to have the investigation ended, so it's in the solicitor's best interest to not engage with you, and if they do that, that cannot be surely grounds to dismiss the case, because the solicitors are refusing to comply. However, you have utilized that particular aspect of grounds, which in other circumstances would maybe relevant, under these circumstances, the state that I have been obstructive, that is evidentially wrong, because I have not been obstructed. I've simply explained to you that, look, this is a new set of evidence, audio recordings. I would obviously make it all available to yourself. I mean, to ask for it to be snipped out into MP3 files is disingenuous or burdensome. Alternatively, you could say, Mr. Hussain, it is not our policy to request to take evidence in oral form, and we require you to go back and all the audio call recordings to transcribe them. All right. You could equally say that's one of our policies. But can you understand that if that is one of your policies, or should it have been one of your policies, you're deliberately looking to stonewall or sabotage my attempts to provide you with impartial, or provide you with evidence. Now, I cannot, in good faith, within a very limited amount of time, provide you with transcriptions of all the call recordings that I made. Luckily, you've not asked for that. But if you were to ask for it in such a format, you can say, well, it's our policy that we do not take call recordings in audio format. We require everything in writing. You could make that policy up, but that would be another example of a highly prejudicial policy. So that's all I'm just trying to say is that the way that you've approached this, you first of all, in that call on the 4th of May, explained to me that I'm not sure if I can watch a YouTube video. I need to get further advice from the Ombudsman. And then you proceeded to explain to me that I need it in an MP3 format, because you've then automatically thought, well, this is going to prove problematic to me, because if I'm having to listen to like hours and hours of worth of calls, which is going to take up the time and resources, maybe I would want it in this particular format to suit my agenda. But you've already not even discussed it with the Ombudsman at the time. You've already stated that you want it in this fashion, namely snippets in MP3 format, to counter specifically, your the 20 points that I raised. So that, I think, is like you've not even sought the advice which you're telling me you're going to seek, and then already you're asking for it in a particular format. So that is an example of being highly discriminatory, and then utilizing that as a pretext to end the investigation. So that's my comment in relation to your grounds that I was being obstructive. I would argue that you are factually mistaken and wrong. I was not trying to be obstructed. I was simply trying to give you information. I was effectively trying to be effective and efficient with my time and resources, and you are effectively trying to be efficient with the public, the Ombudsman's time and resources, and that's fair enough. But there has to be that, there's going to be that toing and froing for you to say, well, no, you're just taking up, your method is going to take more of our time and resources, and we want you to give up to your time. I think that's highly unfair, and then to use that as a ground to dismiss the investigation is once again highly prejudicial. So that's the comments in regards to you explaining that one of the grounds is because I was being obstructive and not cooperating with the investigation. I don't believe that's justified or evidentiable. The contrary is true, that I have from the beginning trying to communicate with yourself and giving you, cooperating with this process. It is obviously understandable that I've not gone through this process before. This is a learning curve for me, and I'm just trying to understand how I can be efficient with my time and resources, just as you're being efficient with your time and resources. Is that understood?
Yeah, of course. Yeah, absolutely understand. I've noted that down.
Okay, so moving on to the next comment, you had stated that one of the justifications you found is that basically there will be no one of the arguments that you've said is that, well, there is no reasonable prospect of preemptive complaints being upheld, because those complaints do not prove a poor service, because at that stage the solicitors were rightly not looking to engage with you, and therefore they were not, therefore subsequently any complaints that you've had once the official solicitor's involvement and the solicitors had basically taken instructions from them, if you're now arguing that you didn't receive a good service because obviously the solicitors were acting under the instructions of the official solicitor, then that by its very definition will obviously there can be no grounds for those complaints to be upheld. Now, that's what the comments that you've said. And in response to that, I once again am vexated and disagree, aggrieved at the approach that you've taken. And the reason for this is because, as you're aware, that circumstance happened in October and November when the official solicitor took over the role. So subsequently, you and we've sat down and we've put in, I believe, something like 10 preemptive complaints or 12 preemptive complaints. And those preemptive complaints were only in regards to a time when I was not basic complaints were when I was under or when the solicitors were under the instructions of the official solicitor, because they had established that lack capacity. So, on the one hand, you did not tell me this back in January, February, when I was making these complaints. When I told you, look, these complaints, I have not had an opportunity to send to the solicitors because they were preemptive. And the reason that they were preemptive was because an opportunity was not afforded to me. You had sat down and been fully aware that these complaints were preemptive and covered a time period when I had, when the solicitors were under the instructions of the official solicitor. So at that stage, you could have told me that, well, you have in the past told me that these complaints I'm not willing to investigate because they have got no likely prospect of succeeding. So, but because in January and February you had effectively taken these down and agreed with me that they will be investigated as preemptive complaints. So you've accepted them, and then subsequently in May, when you've made an evidence request and the other party have disagreed, then now at this stage you're basically grasping at straws, I feel, to find another justification. And you've said, well, here's another reason why I believe that this now fits into the schedule of the ombudsman's disregarding the investigation. Here I've got another excuse. Well, I'm going to say that they could not have possibly provided you with a poor service because you were not their client at that time, or they were not taking your instructions. They were taking instructions from the official solicitor. So when you've made that as a grounds to dismiss the investigation, now you have effectively shot yourselves in the foot, because now you're claiming that had no reasonable prospect of succeeding and therefore that investigation should end. But previously you've accepted it that it does have grounds, and therefore it's been put to the other party. So therefore I just believe that's a further example of you desperately trying to find some or any pretext to end this investigation. And that was, you had a eureka moment where you thought you could utilize that, but by utilizing that as an excuse, now saying that, well, this particular complaint has no prospect of succeeding because it was done at a time when the solicitors were receiving instructions from the official solicitor, that is going to be a grounds to dismiss the investigation. So that's what my comments are in regards to this. But you will understand that your interpretation of facts is not correct. That, even though the official solicitor was giving instructions to the solicitor's firm in regards to proceedings, the solicitor's firm was still engaging with me in my capacity as their client, so I could lodge complaints with them. So my formal complaints and subject access requests were being lodged with them. They were engaging with me. It is not the case that all of a sudden we've got the official solicitor, we do not want to deal with our client anymore. That was not the circumstances of this situation. The official solicitor, there was a grace period when the official solicitor came on board, and the role of the official solicitor was simply to give instructions to the solicitors in regards to ongoing proceedings. That does not have any bearing on my right as a citizen or as a service user, because they could not say to me, well, now that we've got an official solicitor and we've established that you lack litigation capacity, that prevents you from, number one, making complaints or raising complaints to us. They did not say this, and they complied with the complaints. Number two, they did not say, well, you are no longer seen fit to make subject access requests. They did not say that, even though that they had fraudulently established that I lack litigation capacity and got the official solicitor involved. So they did not say that. And for you to effectively look at any kind of desperately looking at any kind of pretext and said, oh, well, this for these preemptive complaints or these select number of complaints, they're effectively not going to be upheld, or because there's no evidence that they're a poor service, because the solicitors at this stage were not providing you with the service, but to the official solicitor. So if we are to investigate this, that's automatically not going to happen. But what you fail to understand is that you yourself have said that we will investigate this. So you've taken up my time and resources in explaining this. You've agreed to this, and then subsequently, in your desperation in May, you're looking to find any kind of pretext or an excuse to not investigate this. But even if that was true, even if it was the case that you could not investigate those particular complaints, that is still not grounds to dismiss the entirety of the investigation. Because the entirety of what you're now suggesting is that, oh, because of this one little thing, the whole investigation needs to be, discontinued. And that, I feel that you're acting with malice and disingenuity, because okay, of the 20, you can then argue them down and say, well, this is not going to work or that's not going to work. But to simply find a pretext to dismiss the whole investigation shows, a malicious intent on your part, because you're effectively now looking for evidence or means or something to substantiate your decision to end this investigation. And this is just a further example of where, at this moment you're saying, well, oh, I can actually use this to dismiss the entirety of the investigation. And my argument is that even if you were right and you found that one or two of the complaints were not going to be found, or would not after an investigation would not be evidentially prove that there was a loss of service, that is not the grounds to dismiss everything. I mean, you have to then go piecemeal by the 20 complaints that I've raised and specifically tell me why those are not going to be investigated now, having previously stated that they are going to be investigated and then made an evidence request. So in regards to this aspect where you've stated that, or because it was established that he lacked litigation capacity and an official solicitor was involved, and therefore we will never be able to establish that the solicitors provide a poor service, and that's the grounds to have the investigation dismissed. I believe that once again that highlights a prejudicial approach and is obviously unjustifiable, because if that is the case, then you have effectively shot yourselves in the foot, because you agreed to investigate this. You've made an evidence request and then all of a sudden looked for grounds to dismiss the entirety of the investigation, when under such circumstances only partial of the investigation should have been discontinued, not the entirety of it. Is that okay?
Yeah, I've noted that down. Yeah.
Okay, so moving on from this, you've also there is two grounds of your schedule that you have utilized. One of those is I'm just trying to remember off the top of my head, is that there is not enough evidence to uphold the complaint. That's one of the criteria, isn't it?
Do you mean the scheme rule? The scheme rules?
Yes. Yes, the scheme rules. Sorry, go ahead.
No, so there was two, if you recall. So yes. There was what we said, I think that it copied the scheme rules as well, as we discussed. So there was 5.7a, which means that we felt the complaint does not have a prospect of success.
Yes.
And 5.7n, which ends for November, yep. Which is where we feel there are any other compelling reasons that we should not investigate the complaint. Yeah.
So it's correct that there's A and N. I'll just refer to them as A and N for simplicity. Is that okay?
Yes.
Okay.
Yeah, of course,
so A is basically stating that there's no prospect of success, and N is basically a catch-all situation, isn't it? That's for anything else. All right. And so basically, what I've been speaking about is the catch anything else, where effectively, because I've gone through all of the other criteria as well, A, B, C, D, E, F, and all the other ones, and they are very, limited in scope. Whereas, the criteria N is very open-ended. It's not specific, is it? It's basically a catch-all catch-all criteria for anything else, because all the other criteria, A, B, C, and D, whatever, they are very specific and objectively discernible, whereas criteria N is effectively or anything else that you feel, and therefore you've utilized, because I've tried to fit in how the investigation could be discontinued. Should I want to discontinue, should I have the intention to discontinue this investigation on that scheduled criteria list? So if I've taken an objective view and I said, well, if I was in Sian's position and I was looking to effectively end this investigation, which one of these criteria could I utilize? And obviously the criteria N can always be utilized because it's very subjective and it's very broad. So you've obviously been utilizing criteria N to justify your discontinuation of the investigation, and we have in this call discussed some of those criteria that you provided. However, the criteria A is very, very limited. It's not broad. It basically states that if there is no prospect of success, then that is a justification for the investigation to discontinue. And you've utilized criteria A. But before I move on to criteria A, can I just ask, have I addressed all the points of criteria N that you have justified to discontinue the investigation? Have I given your comments on all the particular points?
Yeah, and I've taken note of everything. From what I understand, I think you've pretty much covered the document that I've provided.
Yeah, I mean, I read it this morning. I can't, obviously, I don't have it in front of me. There's not another pretext or another justification to end the investigation under criteria N, is there? That I've not given a comment on?
No, I think, as far as I'm aware, I think we've covered your comments on that. So other comments regarding, it would not be a good use of our time, that you've disagreed with our processes, we've discussed the evidence requests, etc. So yeah, from what I can see and what I'm aware of, it sounds like we've covered everything regarding that point.
Yeah, and I think there was just something else comes to mind. I think one of the excuses that one of the reasons that you've given is that there was I would never be satisfied. But I explained to you in that conversation that we had on the for 4th of May that I was satisfied. I mean, everything else that you've utilized, I'm saying that those were only comments given to you. There was no expectation of you. I fully understood the expectations of your the role of the ombudsman after having lengthy conversations with yourself, and you've been at length explaining this to me. You've explained to me that on the worst case scenario, there would be, I think, a £50,000 penalty to compensate you for a poor of service. I then explained to you that would not be justified. I mean, that obviously is not going to be satisfactory, because how is £50,000 equated to the loss of my mother's life? And obviously, I'm never going to be satisfied. But that should not then be utilized as an excuse to end the investigation. And that's not. I do not expect that to be for you to be at fault with that. I expect the ombudsman to fully do their job and due diligence and do their job. And if they've done that to the best that they can, I'm not satisfied, not because of the ombudsman, because of my grievance with the solicitor's firm, or even the wider context. Now, so that is the reason that obviously I'm countering your argument that Mr. Hussain was never going to be satisfied, and therefore that is a grounds to dismiss the investigation. I don't think that's right, because I was expressing my opinions only. So I believe I covered all those things. So anything else that you've utilized under the scheme criteria N, I'm saying that my comments are that those are not justified, and you've spun and twisted things in order to fit, give a pretext or have an excuse to meet criteria N. So I feel I've covered or fully commented on your justifications for criteria N, and I feel none of those are justified, and the ombudsman should take that into consideration. Now, moving on from that, you also utilize criteria A, which states that there is no reasonable prospect of the complaints being upheld. That's correct, isn't it? You've utilized that as well. Yes?
Yes,
You're
correct.
right.
Yes,
Okay.
that's
So,
the reference to that scheme rule. Yeah.
so these are my comments to this, because I've come across this term preemptive complaints, because obviously you've told me in the past that my complaints are preemptive because the solicitors firm have not had an opportunity to deal with them. Now, with regards to the preemptive complaints, I've explained to you that, just before I deal with the criteria A, you've explained to me that the approach that you're going to take with the preemptive complaints is that you will allow them 8 weeks to address the preemptive complaints, and you said that's only fair because they do have 8 weeks from whenever you put a complaint in. And so we had one set of preemptive complaints, and then obviously I made you aware of further things, and you said those are more further preemptive claims, so we're going to give you a further set of, given the further time allowances. Now I'm just going to complaint or raise my grievance on the approach that you've taken, and so these are more to do with the approach that you've taken, which is discriminatory. So the approach that you've taken is that, well, I'm going to do it, consecutively. So I'm gonna, because I'm gonna take your complaints, which were originally for non-preemptive complaints, and then you've made a set of preemptive complaints, and then you've made another set of preemptive complaints. I'm gonna wait for all those to be fully put to the other party, and then make an evidence request. And I feel that the approach that you've taken is once again highly discriminatory, because you were fully aware of the initial complaints that were not preemptive. You could have run those concurrently, not consecutively, with the preemptive complaints, and therefore an evidence request could have been made at the earliest stage, where you would have been then, I would have then been aware of what, and you would have then had an opportunity to state to the solicitors firm, well, irrespective of the preemptive complaints, you can have more time upon them. But I am making an evidence request for the complaints that are not preemptive, and so I can continue my investigation. The approach that you chose of consecutive, handling the complaints consecutively, was highly discriminatory to my part and beneficial to your part, because you then were in a position to effectively not do any work on the investigation. You had non-preliminary complaints. You could have made an evidence request at the start in January or in February to continue the investigation on those particular complaints. However, while you were investigating those complaints, other complaints the preemptive complaints would have been running concurrently. You chose not to do that. You chose to wait until the last minute, until the end, which then resulted in making substantial evidence requests to 20 complaints. And then having realized that, and you've agreed with me in our previous conversation, that this complaint of mine would be classed as a complex case, and I pulled you up on this, and I said, well, what do you mean by complex? It doesn't seem that complex to me. And you said the word I'm using, complex, is because it's like 20 complaints and there's a lot there. So I said that my understanding, so we had a difference of understanding of what complex is. You were saying that because there's a lot of complaints, that makes it complex, and I was saying that it's only one complaint with one organization, or what I would argue is complex is when there's a multifaceted complaint with many ongoing concurrent organizations. So if you recall, we had that conversation and you said it was very complex, and so therefore I feel that you have, by the approach that you've taken and through your understanding what the word complex is, namely numerous, that you have, the approach that you have taken is sabotaged the investigation from its own onset, because you've made it complex. You have effectively waited until the end and then requested the evidence request. However, you could have simplified this, but done some work about it by, investigating the first non-preemptive complaints, making an evidence request. Then it wouldn't have been complex. But then, because of the approach that you chose to take, which was effectively, I don't need to start this investigation until I've got more time for the solicitors. That then inevitably resulted in over like 20 different complaints, which according to your definition is complex, which then obviously you're now stating that because of this complexity it's unjustifiable on a waste of the resources of the Ombudsman. But fundamentally, to address and comment on your comments regarding this, you have sabotage this investigation from the beginning by effectively not asking for the full case file, so there would have been no need for evidence disclosure. You have sabotaged this investigation by making the requests consecutive, not concurrent, where evidence request which would have been which would have obligated the solicitor's firm to comply and provide you with some evidence. And we're now in June, and at this stage 6 months later, the solicitor's firm have not provided you with one piece of evidence. And it's the approach that you've taken, and then you've utilized the approach that wrong approach that you've taken to then justify your decision to end the investigation. So I feel that that is further grounds that you've utilized, that it's not in the public interest for the ombudsman to pursue this case, when effectively you've sabotaged this case and had no intention of having it investigated. So those are my comments in relation to this. So now, is that understood? Yes.
Yeah, I've noted
yes.
that.
Okay, all right.
I think it links into your comments at the start of the call. So yeah, I've noted
yes,
that.
Yes. Okay. So with regards to the criterion A, I believe that I believe the use of the word preemptive is far more appropriate now in the normal sense of the word preemptive, because your decision to utilize the fact that there's no prospect of any of the 20 complaints lodged with you over a period of over 10 hours, over a period of 5 months, that all of those complaints, every single one of them, has no reasonable prospect of succeeding, all right, is preemptive of you. And the reason it's preemptive of you is because you made this decision on the 4th of May. And that you made that decision effectively after the 4th of May or before the 11th of May. But at this stage, you have not received evidence, all right? So for you to state, I believe, yes, the schedule criteria A is relevant at a stage of an investigation when the investigator has effectively wrote down the request, which you have done, made the evidence request, okay, which you have done, received the evidence request, and from receiving the evidence request determined that, well, wait on a minute, there is not enough evidence here to substantiate the complaint here, and therefore the investigation should be discontinued. But under these circumstances, you've not even reviewed the evidence, all right, and you've preemptively utilized that as a pretext. Can you understand that you have acted preemptively in your decision to end this investigation at a time when effectively at this stage you agree with me that you have not reviewed any evidence from the solicitor's firm? Number two, you effectively have not reviewed any of my evidence that I've submitted to you as the audio recordings, because I've not provided them with you in the correct format. So you've not had an opportunity to consider any of my evidence. So the answer is, so in order to comment on this aspect, which further goes to highlight your ill intention, is that you've utilized criteria A, saying that, oh well, none of these 20 have any prospect of succeeding after the investigation, because they're not gonna, there's no prospect of them succeeding. But the question arises is this, that how can you at the stage on the 4th of May, or even at this stage, have any judgment of the 20 complaints that I've lodged with you when you have not been privy to any evidence? All right. And so this is the problem that you have here, is that you have previously, through our conversations, accepted that they're going to be investigated. So you already agreed with me, where you have felt and you have passed your judgment and said, yes, I feel that the scope of the ombudsman can investigate these, so I am gonna put these as one of your criteria as a premature complaint. I'm gonna put that to the solicitors. I'm gonna get their feedback. So you've already agreed that they are investigatable. Now, you've then come to the conclusion that they have no prospect of succeeding, but you could only have make that value judgment after something else has happened, after a change of circumstance, and that change of circumstance can only arise when you've received or had evidence submitted, because effectively what has changed, you've not received the solicitor's evidence, you've not received my evidence because it's not in the right format. So how can you state that the investigation should be discontinued because it has no prospect of succeeding? Because previously you've contradicted yourself, because previously you've said that I do not know whether these complaints have a prospect of succeeding because all I've done is captured them. All I understand about the complaints at this stage when you were taking them down is that yes, they do fall under the scope of what we as the Ombudsman can investigate. So you've accepted them that they can succeed, but the matter needs to be investigated. Now, should you have commenced your investigation, and the commencement of the investigation, what I'm referring to here is that when you had started to sniff through the evidence and then come to the conclusion that, well, wait on a minute, there is no evidence here to support these allegations, and therefore I'm advising the investigation to stop now because they have no prospect of succeeding. Should you have chosen that path, that would have not been preemptive. But because you've made the decision to effectively shut down this investigation without effectively seeing any evidence, then that effectively is a preemptive decision, and you cannot make preemptive decisions without effectively having evidence in front of you. You've not received any evidence, and you've automatically made the decision that these 20 complaints which I have previously accepted that do fall under the scope of the Ombudsman, which I've then made an evidence request for, which has the evidence request has not been responded to, but I'm automatically jumping the gun and preemptively stating that that is another criteria to end this investigation. So those are I believe that you have effectively shot yourself in the foot by making that preemptive decision to end the investigation, because what you could have done, or what you should have done, have said, come back to me and forced me or asked me to give you the evidence in the required format. You should have waited until the other party has given you the evidence, or at least that by receiving the evidence, that would have been a change of circumstance on the investigation, because evidence has now been submitted, and through your preliminary evaluation on the evidence provided, and on that basis alone, you were within your rights to dismiss one part of the investigation or all parts of the investigation, and that's what that criteria A is there for. But you have misappropriated criteria A for your own benefit to discontinue this investigation, because you had no intention of investigating this matter, and as I've explained, you have desperately tried to fit in some criteria to discontinue this investigation. So I believe now I have covered all the grounds for the criteria that you've put forward. And now, in addition to this, I would just like to add that the reason that there's been a change of circumstance is because following my conversation with you on the 4th of May, I then proceeded to write out to both you and the Ombudsman directly via email. On that email dated the 4th of May, I proceeded to provide you with a link, submit a link to the audio evidence. What I had also chosen to do was provide you with further information, and the purpose of that further information, I think one of the comments that you've stated is that it was my intention for you to do something effectively, to go to like a higher authority, and that was the reason I had brought the complaint to yourself, and that was the reason that the complaint should be dismissed, and that's not factually accurate. On the 4th of May, you had asked me, what are you expecting out of this? And it's at that stage that I expressed my only opinion that I would think that if through your investigation you find grounds that there are ample evidence that is a serious matter, then obviously ordinarily I would think that you should escalate that matter to the police or something. But that was not my expectation of you. I was just expressing an opinion. Following that conversation, I had also forwarded to you and the lead ombudsman my complaints to the police, and the reason for that was not for you to find anything in my advantage, because remember, those are outside of the 20 points that I had raised. I had proceeded to provide you with further information and been open and transparent, particularly my complaints lodged with the Greater Manchester Police regarding Mr. Justice Cobb and Mr. Justice Cohen, to simply provide you with context. So I think context and perspective are also important as part of the investigation process, because it's important to find, for me to say, well, look, these were the background circumstances, this was the context that this was took place in, and you are not going to investigate that, and you're not going to look into that, and I accept that. But I think it's very, very important for me to say, look, I'm making these allegations and these are the background circumstances, and that's why I had proceeded to provide you with that information. So subsequently, when I've provided you with that information on that email of the 4th of May, which was sent to you and the lead ombudsman, I believe that it was the decision of the lead ombudsman to have this case shut down, and therefore you have been instructed to have this case brought to an end, and now you're trying to tell me that it's your decision, and hence why, if it was your decision, you would have responded far quickly rather than from the 4th of May to the 22nd of May. I fully believe that the implications are far-reaching to this investigation, because not only has the solicitor been complicit effectively in a murder cover-up, it involves the judiciary and the senior levels of the judiciary and the justices, and therefore I believe that the ombudsman, Mr. McFadden, I believe, is the one responsible to have this case shut down, and therefore they've instructed you to find any which way or any excuse to have this investigation ended, and you have desperately, at the last ditch effort, tried to find any pretext or an excuse to end this investigation preemptively, should I add, without having been privy to the evidence, and you have tried to fit this into a criteria which would then justified, and then you've told me that these are your decisions. I do not believe it is. I effectively do not believe that this is your decision to end this investigation. It cannot be your decision to end this investigation, because you are only in a position to effectively end this investigation, or would be in a position to give your evaluation once you had received the evidence. You have not received the evidence from the other party. What you have done is received substantial evidence from myself, and which, if you had taken the time to investigate, it would have been proven that every single one of my 20 points are legitimate, as opposed to the solicitor saying that every single one is wrong effectively. And obviously I believe that the ombudsman has acted with ill intention by instructing effectively you to make this decision. I do not believe that you can make this decision, or you, objectively speaking, anybody in your position at this stage in the investigation would be in a position to come to the conclusion that this investigation needs to be ended, and for the simple fact that you have not received evidence from anybody as yet. However, what has happened is that following my email on the 4th of May, which clearly provides contextual information, not investigative information, I've provided you with the context of all my complaints to provide you with an overview, as a result of which the Ombudsman has felt that, no, we do not want to investigate this matter any further, because it will result in something that we're not willing to do, which is effectively support a person who's making some serious allegations against the senior judiciary. And hence why I feel the solicitors firm themselves were looking to find a pretext, after simply talking to me in May 2022, in 2021, May 2021, after a short discussion with me, were looking to state simply that I lack litigation capacity. I think, if nothing else, in my conversations with you, Miss Sian, or Miss Jeffries, over the last 6 months, and the fact that I have held my conversations and spoken to you, if nothing else, is objectively understandable that I certainly do not lack litigation capacity, because I'm articulate, intelligent. Effectively, anybody to make the suggestion that I lack litigation capacity is actually acting with fraud, and so therefore the senior. Sorry.
Just bear with me. Nobody at this company, at the Ombudsman, that is not part of our job to say whether you lack litigation capacity. That's not within our remit. That's not what I've looked at. We've not raised that issue. I haven't raised that issue with you.
Yes, you have.
I've got no opinions on that,
But you have.
Or anybody at the company will make an opinion on that.
Okay, but I'm sorry, but you have done so because you've utilized that as another grounds to have you've utilized that quite clearly as a grounds to have this investigation dismissed, because you have stated, and I've commented on this earlier, that one of the things that you've stated is that some of those preemptive complaints could not be upheld because you could not prove a failure of service, because at that stage the solicitors were not effectively working for you, they were working for the official solicitor, and at that stage it had been concluded that you lack litigation capacity. So you've already utilized that as a grounds. You're the one that brought that into the context. You've said that
I'll just clarify on that point, Mr. Singh. It wasn't the fact that I was saying it's because you lacked litigation capacity. What I was trying to explain is that because the courts decided that,
yes,
and assigned you a litigation friend, what we would consider reasonable service is that they continue to communicate directly with your litigation friend, not necessarily you.
Yes. So
I mean, I agree. Obviously, I think at this stage, obviously, I've taken all your comments completely, and obviously we've got it all recorded, which is great because that's all in your own words, and the Ombudsman can hear that, which is great because obviously you've given your comments. I think obviously I will disagree on all of the points with you, which I think is not a surprise. And that's absolutely fine. And this is why we have our processes in place and why these ombudsmen make, these independent decisions, because it can happen. Of course, it can with two people with different opinions. So I'll have the phone call is recorded. So I'll get the ombudsman to listen to this. Obviously, some of your comments are in reference to earlier calls as well. So, for example, I'll call on the 4th of May, etc. So the ombudsman will have access to all our correspondence, all our telephone calls, so they can listen to that. And like I said, I'll look to put this to the Ombudsman. I have made a note of some of your comments, but I think the phone call is best because that is in your words.
Yes, no, that's fine.
It's important that they listen to your words.
Yes, that's fine.
Than my own.
Yes, and that's fine. Yes, that's fine. And so I'm looking to end our call now, because obviously I've gone through all the points. I was simply stating that can you understand that I'm noticing a pattern of behavior here, because I've just stated that anybody is quite. I'm just to finish off with Ms. Jeffries is this, that it's evidence to anybody that's listening to this conversation that if anybody has has capacity, litigation capacity, which I understand that Ms. Jeffries, you're not an expert of what that means. Obviously you're stating that that's gone to the courts and they've agreed, and I can only go on what the courts have gone on. But that's the whole point I'm stating here, that you don't need to have a law degree, you don't need to be a judge. Any person with any sense of reasonable could make a value judgment. And in this country, Mr. Jeffries, that's how we work in the criminal justice system, is that we get 12 ordinary people to make a value judgment on the guilt of somebody, because those 12 people are the experts when it comes to making value judgments. So all I'm just trying to say is that in the background of everything that's been going on, just in the way and the manner I've handled this call with yourselves and all the calls, it is any lay person or anybody with any authority, and that what I mean by authority, I mean that anybody that can pass any value judgment will conclude that if anybody else, I have more than capacity to litigate. So I have litigation capacity. I've mentioned references to ongoing legislation which is effectively in this call regarding societal issues, namely the inquest into the COVID-19 handling by Boris Johnson and the cabinet's office access to, take legal action. I've gone and read their statements. So, if anything, all I was just trying to say is that if somebody is promoting a narrative, and that narrative is that I lack litigation capacity, and somebody is not using their own value judgment and concurring and looking to agree with that, then I hold them that they are complicit in the narrative that's being promoted, because the narrative that's been promoted that I lack litigation capacity serves the best interest of not only the local authority but primarily the judiciary, the senior judiciary, Mr. Justice Cobb and Mr. Justice Cohen, who are effectively now responsible for the premature murder of my mother or premature death of my mother. And so therefore it is in their interest to ensure that a narrative has been promoted which has been fully facilitated and with the help of the solicitors firm. Now that's the only point that I was looking to end upon, that there seems to be a pattern of behavior here where everybody's jumping onto this narrow bandwagon that, oh, you lack litigation capacity. And so there's a pattern of behavior where when I raise these issues with the solicitors at the time, remember I explained to you my policy is always to, when the relationships become soured or ending, I make a subject access request. I made that subject access request quite early on because the relationships had failed in May or June, in June or July with Burke Niazi solicitors. So there's a pattern of behavior here. I then proceeded to put in complaints, and those 20 complaints, they have simply stated, no, we disagree with them. Then to come to you, which is meant to be an independent party, namely, the Ombudsman and yourself, Ms. Jeffries, I'm noting once again a pattern of behavior which is effectively on the same effective theme, where you are, you preemptively made a decision which is not in my best interest, which is effectively looking to end this investigation, which effectively is a wasted over 10 or 12 hours of my life bringing this matter to you. But also I have now sat here and been given the first opportunity to comment on your decision. So you effectively informed me initially. We had a conversation on the 4th of May. You've then gone to some lengths to further explain to me over the telephone on the 11th of May. You've then proceeded to write to me, which is always the best option as well, just to clarify things. You've then proceeded to write to me in clear, unambiguous terms all the points that you've raised in order to look to get this case dismissed. This call here today is the first opportunity I've had to comment upon them, and I've provided you with those comments. And once again, just like the solicitors firm, you are saying that I disagree with all the comments that you've said. So, all the criticism or complaints that I have said to you, you're just saying, no, I'm just going to go with the same that the solicitor said, and said, no, I disagree with you. I would like to give you one last opportunity to explain to me exactly, after listening to everything I have stated, explain to me exactly on what grounds do you disagree upon. What have I stated that you believe? Obviously, we are loggerheads. I am obviously making allegations regarding your conduct and behavior and the manner in which you've handled this. I don't believe that I've said anything non-factual. I've basically explained to you that these are the failings on your part. Now, if you're saying simply I'm gonna say I disagree with all of them, I'm giving you an opportunity to help clarify my misunderstanding, which you would argue that I've got a misunderstanding. What have I stated that you believe is a misunderstanding or incorrect?
Well, I don't want to re-go over it all again, as Melissa said after our last phone call that we had. I felt we discussed it reasonably. I mean, all the points that you've made today, and obviously I've taken your comments, are very similar to what we discussed on our last call on the 11th of May. All my views are exactly the same as what I've written out to you, and they haven't changed following your comments. Yes. So, unless I think at this point, I don't think we are going to agree, and that's absolutely fine.
That's fine.
It's my opinion as an investigator and yours as a complainant, and this is why, like I said, we have processes for someone independent to step in, a third party to have a look, and obviously an ombudsman as well, who is more privy to these things and will deal with these issues. So, like I said, I think my comments remain exactly the same as what I've said in the letter, exactly what we discussed.
No,
they haven't changed.
Miss Sian, Jeffries, Miss Jeffries, I think there's some misunderstanding here. I've taken this time to explain to you and comment all back. I was looking to end the call, and it's a comment that you've made now when I was looking to end the call, that you said I disagree with you, and you cannot disagree with me before today. because I've not told you anything before. So I have then proceeded in this call today to explain, respond and give comments to. And, I've then, this call has been recorded, like you said, and I would like your manager to listen to this as in addition to the ombudsman to highlight my complaint. So, but, I'm not asking you regarding your comments of the decisions that you've made. I'm providing you with an opportunity, because this is the first time that you have been given information from me or got a response from me, and so you cannot be reliant on previous calls or previous interactions. You've just basically stated to me after I've commented and highlighted your failures or your what I believe to be your motives. And you said I completely disagree with them. So I'm giving you an opportunity to comment on what I've stated today, because we've not had this discussion before. We've had this discussion today at length. So would you like? Sorry.
I understand what you're saying completely. What I advise is all of the comments that you've made today are very similar to what we've already discussed on the call we had on the 11th of May. Obviously, I think we disagree with how the case has been run. I think I followed all procedures and processes that we have in place. As much as I tell you that I am an independent party, that there's been no outside influence, obviously you're not of that opinion. And I can't change that opinion. And this is why I felt it's not going to be proactive for either of us to continue the discussion, because ultimately I disagree that, I have run the case fairly. I am independent. There's been no outside sources. All my comments stand exactly the same as they were before we had this call today.
Okay, that's fair enough.
I don't think it's going to be practical to keep rehashing it. At this point, I think we need a third party, an ombudsman, to come in and look at both sides of it and come to that decision. And obviously, you do have. I think you said you have a call with my manager as well, so you can discuss all this with him as well. And again, he's somebody who's not been involved in this, so he can look at this, take a step back and have a look, because it's me and you that have been dealing with this. So that's another independent person. I think it'd be best if, like I said, you've got a call planned with him and you can discuss this with him as well.
Well, thank you. And I'm in agreement with you that I think it would be like, we've already been on this call more than what we were scheduled for, and I think if you were to come back and it would just end up being a debate, and ultimately, I'm not going to change your opinion, and similarly, you're not going to change my opinion. What would change my opinion is, facts or evidence. I'm only relying on evidence, and in the absence of evidence, I'm obviously making value judgments of why you've done this or how you've done this. Obviously, you are best positioned to understand why, or what the truth is as far as you're concerned. We all make value judgments, don't we? And so obviously, and I think I do agree with you that I think, because you said that I disagree with you, and I don't think it would be appropriate for us to have that exchange, because if I've only been given that information to you, and ideally that those are going to be escalated to your manager, and obviously you can then express exactly why, the justification of you disagreeing, and we can take that matter further. So I don't think today or right now is the appropriate time, because we had scheduled this call for comments, and I thank you for taking the extended time to fully take on aboard my comments. I'm not going to reiterate them, because obviously you've explained that I already preliminarily told you on the 11th of May, but now subsequently, with the hindsight of actually receiving your written comments, which were not discussed, I believe, on the 11th, there were added points. I discussed all of them, so I feel I'm satisfied that I provided you with all the comments that I have. But because you've said that you disagree with something, I wanted to give you an opportunity to help clarify maybe a mistake I've made, but obviously I don't think that would be conducive. But with regards to this final comment that you've made, that we're all independent, obviously you're not going to change my mind upon this, but obviously you work for the ombudsman, all right? So you're not independent. And this last comment that you've made, that obviously only you and I have been dealing with this case. Ordinarily in corporate structure, there is a supervisor or a manager involved having oversight of every day, regular activity. So if you're now suggesting that your manager has been completely oblivious to the development of this case, I once again struggle to understand this, because the whole point of a supervisor or a manager is to effectively manage the case, and that's just like in any corporate structure, anybody who's executing the word, such as yourself or the investigator, although given given scope are ultimately held accountable to the manager. But what you're now seem to be suggesting is that your manager, it's only been you and me so far, and your manager has not been giving you any constructive feedback or guidance, or directing you at all, and they have effectively been a non-party to this investigation up until now when I'm bringing the complaint to them. Is that what you're suggesting to me, that your manager has not had no oversight over this case since it was assigned to you?
No, that's correct. All investigators, so in my role, we manage the case ourselves. We manage the case ourselves. The only time that, and as I explained to you previously, so our managers are there for if there's any service complaints against, not necessarily how we've conducted the case, but if there's any service complaints against ourselves. The first time I've notified him, I think, is the time that you raised that with me, and that's when I did notify him that to expect a contact, as you expressed, you wasn't happy with my service, and obviously that's a communication you've had with him, and obviously you can clarify that with him when you have that discussion as well.
Okay, that's fine. Like I said, all organizations work differently, but in my understanding is that normally the managers have a general, not day-to-day running of the case file, but obviously a general overview of what direction is taking, and obviously they are on site to give you guidance and stuff like that. But obviously in your circumstances, you're explaining to me that the manager has now had no has no input on the investigation. But can I just ask, how long have you been with doing your job?
I've been doing the job for over a year, though, Mr. C, but I don't see how that's relevant.
Okay, I'll tell you why it's relevant, because obviously my one of the allegations that I'm making is that you've not acted with competency, and the reason I'm asking is that obviously how much experience have you had with this job? Because one of the things that I would like to highlight to you is that initially when we were speaking, I had to make you aware that you're obliged to make me aware that the call is being recorded, and following that conversation, subsequently you've changed, and you've obviously make me aware that the call is being recorded, but initially you didn't do so, and that was obviously a failure in your part, which you've subsequently rectified. And therefore I think the handling of this case, I'm trying to understand for myself that what there is clearly a failure on your part, which I've obviously articulated, which I'll be escalating to your manager. But is that failure due to malice, or is it due to, it can be one of two things, or inexperience, and hence why I've asked you.
I think you're probably best to give those comments to my manager for them to discuss.
Yes, and I will do.
We'll disagree whether my experience is reflected. I think we will disagree on a majority of things.
Sure.
It's probably best to give those comments directly to my manager.
Yes, and you've made me aware, and that's what I will be doing. So hence why you asked me why that was a relevant question. What how long have you been in the job? And you've explained to me like nearly a year. And the last question I wanted to ask is that what training have you received? Have you received any training as part of this job?
Yes, we do receive training extensively for the job. Again, if your issues are how the firm, how the organisation train investigators and things like that, they're comments that you can give to my manager.
Yes, and I will be doing. And obviously, as you can appreciate in this conversation, which I would ask you to equally forward to your manager before I speak to him, so I'm not repeating myself. Obviously, I've commented on the approach that you've taken. And just briefly is that you've not requested the case file from the other party. You said you would not be doing so. I said that's a bad value judgment. You've also decided to hold concurrent complaints with a solicitor's firm rather than running them concurrently. You've done it consecutively. So these are once again value judgments that have not been relevant. So I think that's down to inexperience, and those are the matters I will be taking with your manager. But like I said, those are outside of the call today.
Just to clarify, I feel like my manager will deal with service complaints. Obviously, you can make them comments to him, but they're also the comments you've made today in terms of how I've operated the case, and that'll be what the ombudsman will pick up on as well.
Yes.
So if the ombudsman feels that I haven't, managed the case appropriately, or there's any comments, they'll pick that up as well. I mean, just to make you aware of the process going forward. So obviously, you'll have you contact my manager separately away from this case in terms of the service issues that you think you've had. But the ombudsman's decision, so I'll request that today. I'll confirm with you via your email. Similar with the service provider, I'll make them aware that I've submitted the request. Our normal wait time at the moment is currently around 4 to 6 weeks. But what I will do is I will keep you updated. I will give you an update to confirm that those timescales are still similar. And once the Ombudsman picks the case up, they will make the decision and they will contact you directly. So although if you've got any questions, you're welcome to come back to me during that time and I will update you on timescales. It's likely the next formal contact you'll have about where the case is going to go will be from the Ombudsman directly.
Okay, that's not.
So they don't make the decision then come through me. They will contact you directly.
I understand, and thank you for that clarification. I mean, obviously, we've had these discussions in the past. I think it's very important to have timeframes in place. And you explained to me that at minimum it would be 4 weeks, or if not a little bit more than that. And I understand that. But then obviously, one of the allegations I'm making is that the reason that you've done this is to give the solicitors more time. You've decided from the start of this conversation not to tell me how much more time you've given, but it is only reasonable that at the time that the ombudsman deals with this case, it is inconceivable that the solicitor's firm would not have dealt with your evidence request. So at that stage, basically, what I'm trying to say is that you have effectively, and this is the part of the discrimination aspect, is that you effectively given the get out of jail card to the solicitor's firm, so they don't have to submit the evidence. Because obviously, as you can appreciate, if you give them more time and the decision comes back from, so for example, the solicitors don't comply with the evidence request and the ombudsman decides to discontinue this investigation, then the solicitors firm are not obligated to provide you with the evidence request or comply with the evidence request, because the investigation has effectively ended. That effectively gives them a get out of jail card, so they have effectively in the
with all due respect, Mr. If, for example, the Ombudsman does come back and supports my decision that the case should be dismissed, and the case is dismissed, then we wouldn't, even if the firm provided all the evidence by that time, we wouldn't review the evidence.
Yes. But the evidence,
but I understand what you're saying in your comments.
Miss Jeffrey, the point is that once the at this moment in time, I believe that there's a conspiracy for everybody to assist the solicitor's firm effectively to not have this the evidence disclosed. You've made evidence disclosure requests, as a result of which then you've made a decision that I'm gonna effectively find a pretext or an excuse to end this investigation. But what my point is that, let's just say for argument's sake that which most likely is going to be the case in my opinion, that the ombudsman decides to end this investigation, I am still within my rights to make a case file disclosure request for everything that the case file has, and hence I would then receive as another channels to get the evidence, because ultimately the evidence that the solicitor has, which obviously they've failed to provide me with, and then subsequently you've failed to get from them, quite clearly is highly detrimental and is very reprehensible from the solicitor's point of view. So they are effectively pulling the strings in the background, effectively trying to.
Yeah, I mean, I think, again, we'll probably disagree on that point, Mr. Singh, but your comments are noted. Obviously, I've taken them as part of this, your comments for the challenge on the dismissal. You can express that to my manager if you feel that there's anything, I've sabotaged or I'm giving more favourable service, then you can absolutely make that to my manager, unless it's all captured in terms of this dismissal. But, that's for me to manage with the service provider. And again, just to remind you of the process, the Ombudsman may come back and support my decision, the case will be dismissed or contact you, or if the Ombudsman feels that there are, my reasons aren't sufficient enough and they choose to continue the investigation, again, they'll write to you, they'll write to the firm to say, we believe that we shouldn't continue the investigation because of X, Y, and Z, and then they'll pass the case back to me to continue the investigation. Now, that is, we don't know what way that's going to go until the Ombudsman picks that up. So I know you've made previous comments that you wouldn't want me to continue the investigation. If it was continue to be active, and obviously you can pick that up at that time. So it's not necessarily something to worry about at
Yes.
this time
Yes.
until the Ombudsman gives a decision. But the Ombudsman's going to contact you and the firm directly regarding their decision anyway. So
Yes.
I might not know the exact date they'll contact, because obviously that'll be with them to
Yes.
pick up and make that decision, but they'll contact you directly.
Yeah, and you know, you made that quite clear to me, and I understand this. And like I said, but it seems, but all I'm just trying to say, and this is the start of not just this conversation, but previously from the start of me engaging with you in January, this case. These complaints effectively center around the case file that the solicitor has and is not disclosing to me, and then subsequently you know has not disclosed any part of it to yourself to date. And I feel that is, you know, an overarching theme here, and that is a problem here, and that would have resolved many of the issues. And so therefore, you know, we do need to now wrap this call up, because we have been on it on some time. I feel that I'm just reiterating myself now. I think thank you for affording me the opportunity to fully express myself. I believe I've covered all the points. I don't think there's anything else to cover. I've discussed all the comments or the grounds that you provided. I've you know given the justifications of why they're unjustified. Obviously my concern, and as you can see, that's a running theme throughout my conversations with you, is that I need this evidence from the solicitors firm, and if they're refusing to provide that up here to me today, considering that they've been paid at public expense, at some stage that's going to come out, because obviously they can't hold on to this case file, because you know, obviously the wider context, Miss Jeffries, is that this matter, my mother's death, has not been investigated by the police, even though I made them aware of it. And also, more importantly, there's no inquest that's been held into my mother's death now, you know, a year and a half later by Bradford Council, because it incriminates them. So basically, this is an opportunity for the Ombudsman to continue this investigation, which sheds light on a serious failings of a joint enterprise by the senior judiciary and senior organizations, and so in collusion with you know, solicitors firms. So a lot of professional people are involved in this, and this has an impact on society, because what if I'm stating what I'm stating is correct, then quite clearly the members of the public's lives are being endangered. And I would finally, my final words are to encourage the Ombudsman to have this matter fully investigated, because it is at public expense. At some stage it will get out, and obviously it will look really badly on the Ombudsman if at this stage they're looking to dismiss an investigation that's taken up more than 10 to 12 hours of my time, just simply talking to you and getting this conveyed to you. I think it's a good use of public resources, and I would encourage the Ombudsman, after listening to this conversation and all my previous conversations with yourself, to establish the fact that you know, this investigation should continue. And so therefore I'm looking to end the call, and wish you a good day, Miss Jeffries.
Brilliant. Thank you very much for your time, Mr. Sian. Thank you very much.
No, thank you for your time. Thank you. Goodbye.
Take care. Thank you.
Goodbye. Bye-bye. So once again, you know, they've been. She was initially trying to give me half an hour. So then I proved to her that half an hour was not enough. So she then proceeded to give me all the time that I needed, because ultimately, if she just looked to restrict me for half an hour, then I would have come back and stated that we can do this for another day. And can you see that how the very, very keen to this deadline date that's been set? All right, she was very, very keen to bend over backwards, because obviously I believe that they have received instructions from a external party, not the Ombudsman, but somebody higher up, or far more in the hierarchical structure, maybe, you know, a senior minister of affairs, or somebody very, very senior, who have said, look, we want this investigation simply to be, you know, ended off with, because it just sheds, you know, clear light on our systemic failures and fraud and corruption. So what we want to do is we want to bring this quickly to an end. And so she was instructed to end this investigation forthwith. She's given me a deadline date of the 5th of June, which was yesterday, and I explained to her, well, if you're sticking to that deadline date, then I would like an extension of time, and so she's agreed to speak to me today. Was going to give me only 30 minutes, and obviously it was not enough, and she knew it was not enough. And then when I tried to make the argument that, okay, we'll leave it for another day, which would have set the it going delayed in getting it to the Ombudsman. But the Ombudsman is quite keen to have this case simply dismissed with, because they don't want to take you on board. And like I said, it is unjustifiable and very preemptive of them to end the investigation when effectively they've not received any evidence. They don't want to receive the evidence or have investigate this matter, because ultimately it exposes the senior judiciary and senior members and the system itself, the Ministry of Justice, the Office of the Public Guardian, and the solicitors. And these solicitors, Burke Niazi solicitors, are my key into exposing all of it. It's all a multi-joint enterprise guardianship fraud committed by, it's very, very systemic. And ultimately, my only key into this whole game is through my solicitors, because they were effectively my solicitors to start with. They eventually looked to have that turned around, so the official solicitor was giving them instructions rather than myself, and looked to effectively silence me and basically shut me up by the avenue of saying that I lack litigation capacity. Now, if effectively, if the Ombudsman ends this investigation, he is promoting the narrative that I lack litigation capacity, and that, although it may seem innocuous, that is a very serious matter, because they're effectively trying to promote a narrative where I cannot take any legal actions against anybody. And it's evidently clear that I, more than most, have clear capacity. I don't lack anything, and the local authority need me to lack litigation capacity, so I can't pursue any legal action against both the local authority and or everybody else. Now, if the solicitors have concluded that I lack litigation capacity, I'm therefore my ability to give instructions to a solicitor to prosecute the solicitor's firm would be obviously brought into question, because the solicitors themselves had preemptively brought my litigation capacity in question when I had sought advice from my solicitors of what I should do when the senior judiciary, particularly Mr. Justice Cobb and Mr. Justice Cohen, have had their services privately commissioned out by a third party, namely the local authority. And it's at that point they were started to say to me that because you hold these opinions and we believe that you lack litigation capacity, so effectively the solicitors who are meant to be independent, Burke Niazi solicitors, who got me a barrister, Asma Nizami, who's also meant to be independent. You see, this is the fundamental key here. They tell you they're independent. She, in this conversation, saying she's completely independent from her own manager. She's completely independent from the ombudsman who she works for. So you see, this is the criteria that they use. Oh, we're independent. And they're not independent. None of them work independently. They work collectively, but they only give you the impression that they are independent to fool and trick you and to manipulate you in order to justify their malevolence. None of them are independent, all right? They all are Orwellian pigs eating from the same trough, and they'll tell you, no, I'm different, I'm an individual, I'm acting independently from this person, yet you're all on the same payroll. How can Sian Jeffries state to me that she's simply an independent investigator when she's employed by the legal ombudsman? How can she explain to me that she's independent from her manager, who's also employed by the legal ombudsman? How can the legal ombudsman claim that he's independent from the investigator and the manager, considering they all work for the legal ombudsman? They're looking to fool me, to tell me that they're all independent within the organization, yet they're all on the same payroll under the same corporate structure. Never mind the fact that the solicitors firm Burke Niazi are meant to be independent, yet they quite clearly worked in the narrative, promoting the narrative of the local authority, whom I was looking to expose for systemic failures in adult social care that they've been failing in. None of these people are independent. They are basically all cooperating and coordinating an effort, hence why she was just so insistent and could not and would not allow an extension of time from today, the 6th of June, considering she had given me the deadline day of the 5th of June, and she was not willing to entertain any delays any further, because the more delays that she puts in place, the closer the window for the Burke Niazi solicitors to submit the evidence request. You see, the whole point is that Burke Niazi solicitors have told the Ombudsman that, look, if we make the submission of this evidence request as the investigator have done, basically the jig is up, everything will be exposed, so we need you to end this investigation. She's received instructions from the Ombudsman through her manager to simply end this investigation, and that she's just been following instructions, and then therefore she's now then explaining to me that no, it was her decision. How can she make a decision regarding ending an investigation prematurely without actually being privy to any evidence? She's not got my evidence officially, and she's not got the other parties' evidence literally. She got my evidence, and with that evidence that they realized that we're going to have to uphold all of his complaints, and if we uphold any of his complaints, he has a legitimacy, because how can this person, who effectively the narrative is that lacks litigation capacity, has successfully brought a legal case has brought a legal complaint to the legal ombudsman and had it upheld? If that is the case, then obviously that negates any understanding that I lack litigation capacity. So can you understand that it is not in their interest for this investigation to happen, because presently they're still on the same narrative that I lack litigation capacity? But how can somebody who lacks litigation capacity effectively and have his complaints upheld, even more so now that she has stated that I don't want to continue in this investigation? It is an undeniable inevitability that the Ombudsman is going to end this investigation prematurely, because he himself does not want to investigate this matter, because he himself has received instructions from an external third party or a higher authority to end this investigation. So that's effectively what they're looking to do now. It just does not make any sense how Sian Jeffries can conclude that the investigation lacks merit, or based on what, when she's not even received any evidence. They have received my evidence, they have become aware, and they're not aware that my position is undeniable, and the solicitor's position is untenable, and so therefore they are looking to find another way to basically stonewall me, and the reason that they're stonewalling me is so effectively they can end they can stop exposure of what's really going on here. It's all fraud, it's all corruption, it's all malevolent, and it's all been carried out by the senior people in the authorities, the establishment, and the authorities in charge, namely the Ministry of Justice, namely the justices, the courts, the everybody, and everybody colluded and conspired in order to forcibly get my mother vaccinated, to kill her off prematurely. So the word prematurely I made reference to, she's telling me my complaints are premature, yet the reality is that she has prematurely looked to end this investigation and I anticipated this as well, hence why I equally recorded all my interactions, and have kept a meticulous detail of my calls. And as you can see from the start of the conversation, she was telling me that our last call previously was on the 15th of May, when I had to correct her and say no, it was on the 11th of May, and she agreed with me. So quite clearly this person is very, very incompetent, lacking experience, but most importantly I believe she's acting with malevolence under the instruction by her senior management and the ombudsman to effectively end this investigation. And what they've done is they've shot themselves in the foot, because they've effectively on record not been privy to any evidence. So how can they at this stage state that it lacks any credibility to be investigated when when they've not received any evidence, and previously they've accepted that it will be investigated? Now they're all of a sudden grabbing at straws and effectively coaching me to give them answers that fit into their criteria to have the investigation ended without my prior knowledge. So she was quite clearly coaching me on the 4th of May to give answers that would have helped her fulfill fulfill the criteria and justified ending the investigation. Yes, they're looking to end the investigation, and no doubt when the Ombudsman writes back to me and ends this investigation, he then effectively has made himself an accessory to my mother's murder cover up. So I'm quite happy for them to end it. What were they going to do? The best case scenario was they were going to effectively get me £50,000, which is peanuts compared to how much I've lost, which is peanuts compared to how much money the solicitors have made. And effectively, this legal ombudsman will only prove themselves to be inherently corrupt and fraudulent, and will prove themselves to be nothing more than a showpiece to fool the public, and have no effective powers themselves to do anything. So I'm although going to be disappointed if this investigation is not continued with, but it's not something that is critical and relied upon. All it really will effectively will do with evidence that even the legal ombudsman, I think his name is Peter McFadden, I think, he himself is complicit in this joint enterprise to have my mother murdered, and partaking in this cover up. So ultimately it places the legal ombudsman into a state of public disrepute in their inability to do their job effectively, after having wasted my time in taking meticulous lengths to explain exactly what happened through that very short period of time when I had instructed Burke Niazi solicitors from the start of April 2021 until our conversations ended in June 2022, a period of nearly just a year, about a year, and yet she's refused to get the case file or have any evidence. And effectively this mechanism is now being utilized to help the solicitors get out of presenting any evidence, because soon as the evidence is presented to the ombudsman, I then get a copy of that. I can make a request to get a copy of that, and there's no justification of why the ombudsman should not give me a copy of the evidence requested from the solicitors. So this vehicle of Sian Jeffries is simply a vehicle to end the investigation for the distinct purposes of not being able to receive the evidence request from the Burke Niazi solicitors, which she's made on the 28th of April. And now they are desperately trying to circumvent that, because should the evidence be received by the ombudsman, and should the ombudsman then decide to end the investigation, I still have an avenue to get that evidence. But what they're going to try to do is they're going to give the solicitors firm enough rope so they don't have to comply with the evidence request, and hence why the urgency of getting this matter to the ombudsman, because every day that goes by is a day that the solicitors should be complying with the evidence request. So quite evidently Miss Sian Jeffries is complicit in this, because they're helping the solicitors get out of presenting the evidence, because soon as the solicitors present the evidence to Sian Jeffries' investigation, to my complaints that they've raised, that will then expose systemic failures and that they cannot come out of, and effectively expose the fraud. So this is one of the reasons that Miss Jeffries is now effectively complicit and acting with fraud. But we are yet to see. I'm a very patient man. I can wait another 4 weeks to see how this plays out. No doubt my premonition is that the solicitors firm will not be presenting the evidence to the Sian Jeffries or the ombudsman, with the full understanding that the ombudsman is not going to uphold my request for the investigation to continue, and will look to uphold Sian Jeffries' investigation to be ended prematurely. So they're already going to investigate. So they've already made this decision, and so now it just needs to play out. And this is one of the reasons that they're quickly trying to get the ombudsman to look into this. So I presume it's going to be definitely within 4 weeks, or if not earlier, but not to be delayed much further. And it will effectively give the green light or the get out of jail card for Burke Niazi solicitors to not submit any evidence to the legal ombudsman, which would offer me an avenue to get the evidence that I require to show and evidence the fact that the Burke Niazi solicitors were complicit and acted with malice in helping to have my mother murdered off by the local authority, Bradford Council. So it's all very sinister and all very circumspect, but we'll see how this plays out. Like I said, I'm a patient person. I can wait, and obviously I've spent my time and resources in dealing with Sian Jeffries, who has proven herself to be highly incompetent and acting with malice and malevolence, to me at least, and I hope it can be equally proven to any third party who is truly independent from this investigation to conclude the same, that I definitely do not lack litigation capacity. I am more than competent and clever.